Today's speaker is a good friend of Lomas. It's Dustin Cole, and Dustin is president of Attendees Masterclass. Dustin is here presenting business risk. This presentation was jointly developed by Lomas and Dustin, and all the fun stuff in the presentation today is Dustin's. As everyone knows, Lomas's stuff tends to go onto the dry side. Before I tell you a little bit about Dustin, I want to make a few announcements about Lomas and about some new things at the Florida Bar. Many of you have seen that the new website was rolled out, the new design of the website. Also take a look at the front page to a link under About Lawyers. There's a link there that About Lawyers Helping Lawyers. I worked hard on that committee to pull resources from the various places on the bar's website that many of the lawyers need today, especially today in the down economy. So you will see at Lawyers Helping Lawyers a lot of the free resources that before they were on the website, but they might have been 4 or 5 screens, underneath and hard to get to. Lomas, as the Board of Governors through the Program Evaluation Committee, decided that all of Lomas's seminars will be recorded, will be uploaded to LegalSpan, and will be free. So this means the ABCs of starting and managing your own law practice, trust accounting, marketing, technology planning, financial management for the non-financial professional. All of these seminars have been approved for CLE, and they are free, and that also includes lawyer as employer. I'd like to recognize some of the people in the audience today because, not to embarrass them, but because in addition to being the director of Lomas, I've also been an ALA member, the Association of Legal Administrators, since the earth was cooling. And as a former law firm administrator, I'm proud of my colleagues. Many also serve as public members of the Lomas Advisory Board, and they help Lomas with a lot of aspects of the trends in the legal marketplace and trends in law practice management. Dustin, since 1985, Dustin has worked with hundreds of law firms and thousands of lawyers. I, in fact, met Dustin in the 1980s when he was doing law firm marketing and marketing for other businesses. Dustin founded Attendees Masterclass in order to provide structured long-term support to help firms cope with market changes, retirement and succession planning, leadership, operational and staffing issues, partner disputes, mergers, breakups, marketing planning, and plan implementation. Unlike a lot of consultants in the legal marketplace, I have personal knowledge that Dustin has actually done the work in a law firm environment. He has a broad background. He has a very, very good experience as a retreat facilitator. He's done workshops for many law firms in addition to over 25 state bars. Dustin resides right here in the Orlando area, although he's a native of Phoenix, Arizona, and he holds a degree in radio television from Arizona State. Welcome, Dustin. Thank you.
Thank you. Anybody ever have one of these? It's a dirt bike. I did. At about 17, I saw a bunch of guys out in the desert playing around on their dirt bikes, and I fell in love. And I bought one. And I come buzzing home with it, and my dad saw me. And he says, son, you know you're going to have a lot of fun on that. But one day you're going to have an accident. And let's just hope the first one doesn't kill you. Well, it didn't. But it took 5 years for the gravel to work its way out of the heels of my hand and my chin. See a little scar right there. And I've always remembered that. Because there's all kinds of disasters that come at us. Personal, natural, technological, practice, intentional. And the fact is, one of them's going to happen. Statistically, one of them or more is going to happen to you. The question is, will it kill you or maim you or just bruise you. You have a choice. You can plan and prepare, or you can assume it's never going to happen to you. Why did you choose to practice a law? Well, for most people, someplace in there is something about helping people. Of course, to make a good living, to have a great lifestyle. Boy, has the profession failed on that one. Be respected, build a reputation. Well, it's important for you to understand that you're not just one gal or guy on a dirt bike. You're really a bus. And the whole issue of risk management, and for that matter, the bar rules, is about protecting the people who are riding on your bus. Because you have dozens, hundreds of people's lives and careers and financial futures in your hands. So risk management isn't just something you ought to do to protect you. It's really about making sure that you're able to protect your clients and deliver what you promised to them. So all kinds of things that you hear that you don't want to. My bookkeeper stole $90,000 from my trust accounting right after the evacuation order was handed out, was broadcast. I have, in the last 5 years, I've worked with at least 6 firms, one of which lost $369,000 through one of their most trusted employees. I fired my worthless secretary and she deleted all my files. There's what you never want to see. Just found out my paralegal's been handling clients on the side. They thought I was their attorney. I never heard of them. After tornado hit, we had to shut down temporarily, and I discovered my secretary had been siphoning off money. There are about 10 things that most disasters that make up the list. And 8 of them have nothing to do with your skills as a lawyer. They're all about office management and eminently preventable. Here's the top 10. Failure to manage your time, procrastination. Failure to docket, to identify deadlines. Failure to manage information. Failure to get client consent. To file documents timely, conflicts of interest. This is one of the biggest. Poor client communications, failure to follow client instructions. Only 2 of them relate to your skills. Inadequate discovery or failure to know and apply the law. So risk management is about running an effective business. Now, I know that for a lot of lawyers, when I say you have a business, you get a little insulted. Years ago, I had a discussion with Jay Foonberg. He was on the podium, and he said, I have no respect for anyone who tries to tell us that we have a business and not a practice. And I said to him, Jay, I'm sorry if that's how you've heard what I've been talking about. What I've been saying is you can't have a great practice if you don't have a great business underneath it. So, here's some recipes for disaster. Poor processes, poor procedures, policies. The ABA has a great policies and procedures manual that you all ought to be taking a look at and creating for yourselves. And here are the top 10 processes to take a look at. Intake. Oh, I spend a lot of times with my client talking about intake processes. File opening procedures. I can't tell you how many times I've talked with an attorney and I've said, how many open files do you have? And they say, oh, about, I say, stop right there. If you don't know exactly, you're not in control. Conflict of interest, visitor and telephone call management, email, text messaging. Oh boy. I got a whole program on controlling technology. Email, text, cell phones. It's a growing nightmare for attorneys. Calendaring, task management, file closing and archiving, records management. Huge issue on records management. Most people are not appropriately managing their files and their records. Client status reporting, client communications again. Data and file security management. And it's the small firms that are most at risk because all of the business part in small firms tends to be kind of ad hoc. You know, I got all this work to do, and yeah, I need to get to that thing about the backup on the computers one of these days, and then one of these days it's all over. Small firms don't look at what they do as a business. They don't back up from the legal work and say, okay, how does this need to run as an effective business so that I can deliver great legal work? Oh, we don't need management. It's just the two of us and a secretary. We just talk things over. And often don't. The technician view is one of the biggest issues. If I just really bear down, work really hard, everything will come out all right. Until one day, nobody's asking you to work for them because you forgot a couple of important parts: client communications and client development. No business practices. No, you know, I got to go back to this because very often in my seminars I'll put out something that's just basic practical information on business operations, and somebody will come up to me afterwards and say, that was such a revelation. And I'm going, okay, we need to talk. No hiring practices. How do most small firms hire? Oh, we're on overload, we got crazy, got to find somebody to come in and help us with. That's not hiring. That's dragooning. Grab somebody, get them over here. I had a conversation one time. I said, was talking with an attorney out in, I think it was New Mexico. And I said, what were your total revenues last year? And he said, well, not exactly sure. I said, well, okay, how much did you take home last year? I'm not sure of that either. I said, really? I said, well, tell me about your accounting. He says, well, I have this checkbook. And when I get money in, I put it in the bank. And then when the bills come in, I pay the bills. And then at the end of the month, I see what I have left over and I take it home. Now that's good business practices, I'll tell you. Most disasters you don't hear about. There are lots of them. But the fact is, they only happen to one person. So you don't get a chance to understand the impact and the import of those items. So today is really about helping you protect your clients, your revenues, your reputation, and really about your future. So let's do a little review here. What we're going to be talking about today is what operations that you want to take a close look at, offer you some checklists and procedures and information on how to do it, show you where the resources are. So here's sort of the core of today's agenda. We're going to talk about these items. First of all, structure and governance. You need to look there. Most small firms, a couple, 3 people, well, you know, we just sit down and talk things over. Well, how do you make decisions? How do you divide up the money? What happens if somebody gets mad and wants to leave? How does that all work? There is a firm, in fact, I already saw a name tag from the firm down in, and I won't get very specific, South Florida. That broke up some years ago, and it was 7.5 years before they finished suing each other. And that, just a little bit of distraction. Your intake process. How do you go through the process of screening and identifying exactly the processes for your clients? Are you selective? Do you have fee agreements, conflict checking, What's your process for client communication? Let's look at your technology and security and confidentiality. And then there's the people management part. You know, I heard somebody once said, you know, this would be a really good business if it wasn't for the damn clients. The damn employees. Works both ways. Financial management. Are you managing, or are you just putting things in your Quicken? What's your insurance portfolio looks like? What about preparedness for natural disasters and for business resumption afterwards? Succession planning, leadership, transition, and finally health and work and life balance. Well, not quite finally, because there's one thing we're going to talk about briefly, and that is marketing. There are tons and tons of tools for you to tap into to get the information and make the decisions and make the changes you need. So, gee whiz, I didn't know about that. You know, what's the law? Ignorance is no excuse. Have a disaster, fail some clients, and then talk to the bar about your failure to deliver. If you said, gee whiz, I didn't know, it's not going to help. So, and did you know that you can very quietly and privately search the rules of professional conduct at floridabar.org? You can go back and take a look at things so that you have the ability to better make decisions around client intake, client management. So, one other thing. You know, I have to say this because it's important for us to be real clear on it. The bar rules are not to protect you. They're to protect the people you serve. And they're to protect the profession in general. So you are your brother and sister's keeper. You have specific responsibilities under the bar rules for your partners, for supervising lawyers, for anyone in your firm, any lawyer in your firm. You have direct responsibility to help them operate in an ethical way. And if they don't, you have a professional, ethical responsibility to let the bar know. So that becomes pretty difficult when it's a partner who's got a hand in your pocket. So that's why prevention is better than trying to fix things at the back end. So let's talk a little bit about structure and governance. Talk about the terrible D's. Distribution. How do you divide up money? A constant problem I hear is, well, you know, we got together and we had an all-for-one and we just worked together and then we divide everything equally. So you need to have in writing how you distribute revenues. By the way, that all goes to a compensation structure which most small firms don't have. That delineates exactly how people are compensated in a law firm. The next is decision making. Who can fire? Who can hire? When I talk with attorneys who are coming together as a partnership, I said you need detailed partnership agreements, and in that agreement, you need to have it in writing and agreed to how you will dissolve. Oh, well, you know, we're friends. That'll never be a problem. And I said, yes, it will. I can pretty well guarantee when it comes down to money, when it comes down to you discover one of your partners is on crack, they're going to be reasonable then, aren't they? So how do you do that? And that would have presented the 7.5 years of lawsuits, or at least most of them. Divorce. People get really different when they're going through a divorce. What happens when the asset value of their ownership has to be determined in the divorce? What happens when somebody dies and now the spouse is somehow involved in the whole practice? Disability. Does that person who got half of the gross revenue, who's now in the hospital for 6 months, still get half of the gross revenue? What's fair? What works here? Who can make the firm indebted? All this needs to be in writing. You need to have a partnership agreement that shows ownership percentages, how shares are handled, and 50-50 is a stalemate, it's not an agreement. You need to place a value on the ownership shares. You have to mentally divorce the two issues of the work that we do and how we get compensated for the work, and how the owners get compensated relating to the profit. That's a basic concept that you have to look at. Everyone who works in the firm is an employee, including you. And there is a compensation structure that relates to employees. Then there is profit produced by the company, and that is then divided according to ownership provisions, just like stocks. How do we handle expenses? Who can incur expenses? Who needs to approve expenses at what level? How do we share revenues? How do we control? And how do we dissolve partnerships? The legal profession in the small firm arena is a classic example of the shoemaker's children. I cannot tell you how many times I've talked to small firms, 2, 3, 4 attorneys, and I say, you know, can you show me a copy of your partnership agreement? Oh, well, we don't really need one. You know, we're all in the same wavelength. Yeah, until there's a dispute and suddenly you're not. So would you ever recommend a client go into business with somebody else without an agreement? Never. Never. But we're all of good faith here. We trust each other until. You need to define all of the elements that we just talked about here. Management, financial control, and I don't care if it's 2 attorneys. You need to appoint someone as a managing partner with specifically defined authority to make decisions, specific responsibilities. How do you take clients in? How many of you have ever had a client from hell? Yeah. So the question I might have is, once you got that client, did you ever back up and go, okay, what did we do wrong that let that client in here? What questions didn't we ask? What didn't we find out? What didn't we do? So every firm needs an intake form so that you can gather enough information to make rational decisions, to set up a file, to do a conflict check, to basically protect the firm. And there are basically inquiry and client intake forms of all sorts. I have several myself. Is the matter in the firm's area of expertise? As the population of lawyers grow and there are more and more small firms, there are more and more attorneys that are slipping back to threshold law. You know what threshold law is? Anything that comes across the threshold. I had a scary, and by the way, the rise of all kinds of software that I can buy to do things is really scary about instant experts. I talked with a lady out in Denver who had moved up from Fairplay, if anybody knows Colorado area, and she was trying to reestablish her practice, and she didn't know quite what to do. She says, you know, I'm thinking of buying some bankruptcy software and going into bankruptcy. I don't know anything about it, but I can buy this package and just, oh, geez. So you are safer and you are going to be less stressed out if you stay within your area of expertise and don't be tempted by, yeah, but he really would be willing to pay me a nice amount. It might be the last client check you get. Do they have an achievable timeline? Do they have an outlook? You know, what is the client thinking? Do they have reasonable expectations? By the way, if a client ever tells you it's not about the money, it's the principle of the thing, when they get your bill, timeline is so important here. What do they really expect? Is this 11th hour deal? Can you pull it out of the hat? Can they pay? And as I was doing a firm analysis, what I discovered is that they had $332,000 in receivables. Over almost 300,000 of that was over 180 days. Some of it was as old as 2 and 3 and 4 years. Because one of those partners who did family law was really good at bringing clients in the door and getting a retainer check. And then just going to work without regard for what else they could pay. And unfortunately, an awful lot of those people, that's all they had. So send me a bill for $35,000 and I'll go, eh. And that one attorney was responsible for most of those receivables. But he was a senior partner. What do you say to him? So, one of the basic ones. Have you worked with other attorneys on this matter? If you have, thank you for coming in, because you're probably going to be next. Does the firm have the resources and the capacity to handle it? Do they have the needed expertise? You need to actually, somebody once said to me, I realized I'm not a bus, I'm a taxi. I don't have to pick up everybody that stops me. And you need to be usually we do the hire me dance when somebody comes in. You need to turn that back around and say, is this someone that would fit in my practice? Is this someone that's going to be easy, good to work with? All of those criteria. You need to be evaluating them. And by the way, it's not just what's on the piece of paper. It's also sometimes you'll be talking to somebody and all the details look okay, but something is talking to you right here. Ever been there? 80% of our communication is nonverbal. And it probably knows something smarter than this. So if you have a client that just gives you the willies, even though it looks okay, better you walk away because there's probably trouble there. So here's some things to think about. What criteria would require you or your partner, one of your partners, to bring it to discussion before they commit to hiring that client? This is a problem that we have. You know, one attorney is very diligent at the other one takes a lot of clients, has a lot of AR, things of that sort. What criteria do you want to set up and put in writing as far as client intake? And who's authorized to accept work? You see, what I'm talking about in small firms where it's just sort of a handshake and we're just all in it together, we have no agreed upon standards as to how we operate. And inevitably, that results in big internal conflicts, splits. You know, the person that you went to law school with that was your friend for 20 years is now your sworn enemy because you did not set the ground rules as to how you're going to work together. You need to put it in writing, spell it out and agree to it, and both of you, all of you sign it. So let's talk about fee agreements. All I can say about that is always, 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 always. And not just what you're going to do, what you're not doing. You want to make sure that your fee agreement states what services you're going to provide and what you are not going to represent them for. Because that's a place for malpractice. Well, you know, we talked about it and I told them about this thing that was going on and I kind of thought they'd, you know, because they're my attorney for this other thing. Your malpractice insurer, the bar, is not going to want to hear that. So you need to put it in writing. How do you go about the process of billing? What are your payment and collection terms? What happens when they don't pay? The right to, now, here's an issue. You need to have in your agreement the right to request withdrawal for non-payment. Now, in some cases, once the court has appointed you as counsel, you don't get that option. And I'm not saying that. I'm saying the right to file a request. Because the client often doesn't understand that distinction. And when they get a copy of your request to withdraw, it just might possibly cause them to pay. Define your payment terms. What else? Right to file liens for unpaid balances. That's not always allowed. It is in certain cases. Again, this doesn't say you're doing it. This gives the client some understanding of the potential recourse for non-payment. So again, it sets up some very strong rules with the client that is going to have them worry about some other issues. Mandatory arbitration. And something that I'm amazed when I get client agreements, I don't see this on it. That's like, duh! You know, you got somebody from Ohio dealing with the house down here, and you've got an agreement, they're unhappy with you, suddenly they're suing you from Ohio. Venue. Go over it. Talk it through with the client. Unfortunately, how most retainer agreements are done is, here you go, sign right down there. The client's not going to take it home and read it 90% of the time. So they need to understand and sign after they got it. And if they don't want to sign, that's probably one of the issues. Give it back to them in writing. You sign it, they have it in writing. Good way to run your firm into a wall. And verbal memory is not a system. Nobody's brain is that good. You have to have a database, and it needs to be a good one. If you are going on verbal memory, I guarantee in the last 5 years you've had conflicts. Now, since part of my history is with a malpractice insurer, the president of that company said once to me, he says, every attorney has a file drawer full of errors. The only thing that counts is the ones that are discovered or the ones that made any difference. So they're all there. But you can minimize them by having a really good database that is maintained as a priority, consistently checked, identifies actual potential and perceived conflicts of interest, drills down. This is where most people miss. I'm representing a corporation over here, and I got corporation in my file, but I don't have the CEO and the CFO and the 6 guys that own it in my database. So here I'm suing somebody over here, and they go, haven't I seen your firm name somewhere? And now you discover you're suing somebody that you're representing. Boy, that's a recipe for big disaster. And it includes smell tests. Look for the uncomfortable, even though they may not be actual conflicts. Personal public figures, family, friends, employees, civic or religious leaders, your children's teachers. Make sure that you're relating your world to your business. Then there's client communications. If the client calls up exasperated, irritated, frustrated, angry, you need to look at your processes. Kind of basic rule I have is the client has to call you and ask what the heck is going on. You're way too late. You're now in a backup position because every client comes to you in some degree of fear and mistrust. And at every moment, you're either increasing that fear or decreasing it. Understand at every moment, when they call and leave a message and somebody says he'll call you right back and it's 4 days or you don't call, you just set up a possibility for that client to be on your case. And you don't want to be working for a client who has lost faith in you. What are the components? Well, I believe that a great client relationship starts with a significant discussion of how we're going to work together. How does this thing probably going to go? What's the guess on the time period, how the flow is going to go? What are the general steps? Who are they going to be working with? Nothing makes a client more upset or more fearful than getting a call from somebody from your office they didn't even know existed, asking a sensitive question about something. And so, by the way, that's why people say to me, oh, well, you know, I can't delegate any of that because clients always want to talk to me. Well, number one, you set it up that way. You told them, I'm always at your disposal. Call me, I'll get right back to you, and all of that. And number two, you didn't build any trust in that client with any of your team. I want to introduce my great team. These are the people that help me get the work done at the level that I want to deliver it. These are great people, and sometimes I may not be available, and so please feel free to talk with George or with Sarah, because we all work very closely together, and they're great people, and I trust them fully. Now, when Sarah calls and said, hey, Mrs. Jones, I wanted to find out about, oh, okay, hi, Sarah, because I've seen them. They've met them, and you've told them they're great. Who will they work with? How are you going to communicate? What's the best method? What do they prefer? How does that work? What are you going to copy on them? Nothing upsets a client more than getting a bunch of stuff from you, and they go, okay, what's this? What? And nothing is more inefficient for you than having to dictate a cover letter to send it. Develop very specific communications techniques. What I always suggest is all you have to do is have a nice little card with several check boxes on it, and show it to them at the beginning. Now, we're going to be copying you on a lot of things, because we want to keep you in the information stream, but don't have to worry about it, because see this little card? It's going to tell you, just put it in your file, read and file, read and call me, please sign where indicated, please contact me, or whatever. So you'll know how to handle it, how it's important to you. So we go about it from the technician point of view, and make sure they have everything, so no question. And they get all this stuff, and they go right up the wall. What is it? And you get a call. What is this? What am I? At every moment, you're either increasing or decreasing their trust in you. And you want to make sure that everything you do has them trusting you at every corner. For instance, you may tell them, look, I'm in court a lot, I'm in appointments, so if you call at 9 o'clock, I may not be able to get back to you that day, but if I can't, I will always have one of my people call and check in to make sure if they can help or if we need to set a time to talk. What is it? Nothing bothers a client more than calling you and leaving a voicemail and wondering when the heck they're going to talk to you. There are all kinds of really basic management and operational techniques to eliminate that forever. Explain how the retainer goes, when you bill, how you expect payments to go. Talk them through it. It's not enough to hand them the paper and ask them to sign it. Upfront education can save you lots of frustration, lots of angry calls from clients, lots of frustration on your side. Save you money. There's this book, How to Write Bills Clients Rush to Pay. Well, I don't care what the bill looks like. If they're teed off at you, they ain't going to rush to pay it. It can save you grievances. You can get grieved by a frustrated client on something that when the grievance committee comes to call and talk with you, well, there's nothing there. But you spent 2 or 3 months worrying about it, dealing with calls, and you've got a client that is so mad at you that they filed a grievance. They might sue you. And at the end of the day, all of that, somebody once said, a happy customer will tell 2 people about their experience. An unhappy customer will tell 12. So billings themselves are critical in communications. You need to tell them up front. We always get our billings out by the 6th of every month, so you can normally expect your bill by the 7th, 8th, 9th of the month. And you'll also get a bill even if there was no charge that month, because we want you to know there was no charge, and we want you to know we're still watching. Make your bills easy. You know, the whole issue on time tracking has created a legacy of bills that send clients up the wall. How many of you have ever gotten a call because somebody went over your itemized bill and they say, now, you say that we had a conversation on the 17th. Now, I don't remember that, and I know, you know, billings talk about activity. They don't talk about results. And so a client who is unhappy or worried is going to take that and pick it apart. Try to make them positive, friendly. If you're going to write stuff off, put it on there and then show a credit. Don't hide that credit. One of my suggestions that I have is with certain clients, rather than send them the 0.6, 1.5, 6.2, give them a narrative. Dictate a letter. Here's what went on this month. We had several great conversations with opposing counsel. We've moved this forward, and it looks like it's getting closer to resolution. We worked considerably, did some research to find out, and so total attorney hours, total paralegal hours, miscellaneous costs, total dollars, detail billing on request. Because people don't know they really don't want to know what activity you did. They want to know, did we get someplace? What happened this month? What did we achieve? What results are we getting? So the detail billing needs, at the very least, a cover letter saying, what happened? What did we do? What did we achieve? That's a great way to have happy clients. And I guarantee you, unless they're a very sophisticated client, if you do a narrative billing and a sort of a total number, and it says detail billing on request, not 1 in 10 will request their detail. The sophisticated clients require it. But most clients just want to know, have we made some progress here? I put some articles in that I've written, 4 Steps to Building Great Client Relationships, goes over a lot of this. And one that I wrote specifically for family law attorneys, but really kind of applies to everybody, how to protect your practice from crazy clients. And in a lot of practices, you have clients that are not fully rational. They're stressed out. Divorce, criminal are 2 of the biggest areas, but a lot of the clients are that way. So it's important for you to understand that that's going on, even though they may not be showing it on the surface. So those 2 articles might be helpful. Records management is really important, and you have a true ethical obligation to control and manage your records effectively. Not just your current, but all your past. You need to be able to protect them. You need to be able to access them. You need to be able to know exactly how long you should retain records, how they need to be retained. This is just basic stuff that's extremely important. And data protection. There is no substitute for backup. But the problem is that a lot of times when your system crashes and you go check your backup, oh, well, it hadn't been working for weeks, so we've been taking that blank disk home every night. So verify it. Another problem I see in small firms is, yeah, we have a server and we back up that server regularly. Of course, we have no procedure or requirements as to how people work on documents. So everybody in the place that has a computer has a whole bunch of stuff stored on their own computer. So don't even allow local save if you have a server. And if you do allow it, make sure that your IT person has set your backup up so that it backs up all of your local computers as well. Cloud storage. The whole issue of cloud deserves 2 or 3 or 4 hours to discuss, and you raised the issue. Storage itself, it's like anything else. They're a vendor. Research, vet the vendor. There's nothing wrong with cloud storage. There's sort of a fake issue around cloud storage, and that is security. Well, frankly, most cloud, whatever it is, storage or programs or anything, software, the security in the communications and the security of protecting your data is as good or better than your own protection. But you have to know that. And it's not so much the security, it's that are they going to be there when you try to access them? So you need to do it like you would do any vendor and make sure that they meet the right criteria. I know you've been beat to death by this, but it still goes on. Metadata. Documents are still going out with all the revisions and changes, and you need to have an ironclad procedure that requires stripping of metadata. What about IT support? Don't use your brother-in-law's son, because when you have a crash, that's one of the first things that the bar is going to ask you. Well, tell us about your IT support. Well, it was my brother-in-law's kid. Okay, in other words, none. What about your passwords? How many employees have left knowing your passwords? When's the last time you've changed them? Here's something that escapes a lot of people. How many of you are scanning documents now? Okay, do you know that that copier has a hard disk in it? And when the lease is up and you get a new model, that hard disk goes back to them with all of your stuff. So you got to be very, very careful about all of your technology. Smartphones, same thing. You know, I lost my smartphone. There's actually a little program out there. It's an app, basically, that can remotely, if you lose your smartphone, it can remotely wipe it. So be extremely careful. There's too much information, sensitive information that's floating around out there in cyberspace or in equipment right now. So what else? Well, learn to manage your technology, okay? Not so much as a giggle. How do you like that? Who's that? Matrix, Neil, yeah. Now talk about your technology, huh? There's a ton of information out there for you in the Florida Bar catalog, lots of tech periodicals that can give you the basics of managing your technology. It requires more focus than most people are giving it right now. And it's a big hole in the boat if something happens. It can be disastrous to your practice. Not a little bruise, but a serious maim. CLE from Lomas, great program, technology planning for the law office. By the way, I just wanted to say I'm really honored that Lomas asked me to come in and help do this program, because you are fortunate. You have the single best practice management support program in the country in Lomas. Incredible resources, incredible people, and it's just a privilege to, at least for a little while, be considered sort of part of that team. They're just amazing people. So, how do you manage your employees? Start with a firm confidentiality policy. Specific issues about storing data, files out of the office. I had a very specific situation. I was called into a firm that had 19 paralegals. They did condo association law. And in the process of doing an analysis, I discovered that they were allowed to work at home sometimes, like 1 day a week. So I said, let me see if I understand that. What you're telling me is this paralegal has the ability to stack a bunch of files in their trunk and go home and work for the day. I said, Please tell me it ain't so. 19 paralegals trucking files around the landscape. Wow, unbelievable. Passwords, how do you control them? You should be changing them regularly. What's your procedure for terminated employees? Changing passwords, changing locks, get their phones, their computers, get them to sign an affidavit that they have not removed and have surrendered all firm information. There's a whole raft of communication that we use on a daily basis that's not even secure. Your cell phone is not secure. Bluetooth is not secure. Public Wi-Fi is really not secure. And certainly the conversation you're holding on your cell phone in Starbucks is not very secure either. So check your communications and your technology for security, because frankly, most of it isn't. Be very, very judicious in talking with clients on cell phones in public places. For that matter, talking with clients on cell phones altogether. Texting and cell phones are dangerous because one of the most valuable things that you bring to the client is not just expertise, but wisdom and thoughtful consideration. Cell phones and texting encourage reactive responses. Shooting back a quick yes or no to somebody who shot you a quick message without going, wait a minute, let me think about that a minute. Let me go back and look through the file. Let me find out if there's a... Texting, we have gotten into knee-jerk responses with texting, and when a client calls you and you're driving down the freeway and it's busy and there's traffic everywhere and they say, well, you know, what should I do about so-and-so? Well, did you really chew that over? Should you have? Even if it's a simple answer, you betcha. So be very, very careful in allowing technology to use you in the client relationship. Let's talk about financial management. This is about protecting the firm and managing the flow of money. There's all sorts of unthinkable things that happen. Partner theft. Yeah, employee theft regularly. Unauthorized write-offs. You know, who can write off? Who can write down? Same thing as who can take a client in. Do you have any kind of specific requirements about write-offs? You know, I hear this so often. You know, our billing process is kind of agonized. We print out draft bills and then they all go out to the attorneys and they edit them and everything. How much write-off are they taking off of those bills just for whatever reason? Are there any guidelines? Usually in large firms there are, but in small firms, you know, whatever. So are you monitoring, as, quote, the managing partner? Are you monitoring and looking at and asking questions about how come you wrote off half of this bill? Well, because the client probably not going to pay it anyway, so I just wrote off. Wait a minute, you took in a client that you figured probably couldn't pay the whole bill? So are you managing, are you being CFO of your firm? And if you're a sole practitioner, you need to step up to CFO and look at how the employees are working. You need to separate yourself mentally and say, okay, wait a minute. If this employee is having to write so much off, we need to talk to this employee about their standards for client acceptance, for their efficiency and how they work. So you have to be a business manager sometimes even for yourself. Unauthorized charges. Checks. I see this all the time. You know, well, we're just good friends and we agree and you don't have any agreements. So one partner has joined 3 country clubs and taken 2 business trips and, you know, got a new lease on another car. You go, oh, well, wait a minute, some of that money's mine. Well, you know, how do you control that? Theft of client information, that happens a lot. all kinds of great stuff from Lomas. The one thing that you want to remember is anything you want to know, Lomas probably has resources on it. And then there's trust accounting, the single biggest cause of havoc in law firms. Absolutely one of the biggest issues. I just ran into a firm, 11 employees, 6 attorneys. It had grown from a small firm. 5 secretaries were doing bills for their attorneys and were writing checks off the trust account to pay some of the invoices to clients. And I said, okay, why is that? Why are 5 people just willy-nilly able to write checks off trust accounts? It's insane. But what's the magnitude of what's going on for you in that? Trust accounting can sink you. And frankly, the bar doesn't care if you said, well, I tried. I did the best I could. Say, sorry, you're suspended for a year. Let your client know your responsibilities in managing the money that they entrust to you. Educate, and if you have to, intimidate your staff. Do never touch my trust account. You need to make sure that that is fully controlled. And the way to do it is to use a bonded CPA. It's called malpractice insurance. So they are fully responsible for the maintenance of your trust account. That's one of the biggest caveats that the bar will accept. This guy works with 3 other firms. He's bonded. He's supposed to be an expert in it. And there it is. They go, well, okay, that's going to help. Tight written controls. Great LPM series seminar on trust accounting. Very, very good. What about insurance? We're doing pretty good on time here. What do you really need in insurance? Well, we tend to think about malpractice insurance. That's only a piece of it. What about your office package? You need a fidelity bond for employees. You need valuable papers coverage. Obviously, theft insurance. Employee liability. What happens when that paralegal with a trunk full of files is involved in an accident going home to work for you? Talk about a mess. And what happens to the 36 files that they took out of the office that are now strewn across the intersection? So what happens when you send your staff member to the post office or to UPS to send a package and they get broadsided? Are you responsible for the T-bone? Could be. Business resumption insurance. Key man life insurance. Lots of firms that have died because somebody did. Disability. If you could no longer practice, who would take care of your family? You need a partial disability rider with a lifetime payout. And that ain't cheap. This is an area dear to my heart. Professional liability insurance. For 3.5 years, I was vice president of marketing for Rumger Insurance. Anybody remember Rumger? Rumger was a great little company. There's an interesting story about why it isn't there anymore, but we gained a 20% market share in about 3 years. But I learned an awful lot about professional liability insurance. There is no substitute, but you need to be in control of it. And the biggest problem in professional liability insurance is providing false information on your application. Well, we didn't realize. Well, we didn't know about that. We didn't know we were supposed to. So an awful lot of it is not purposeful. It's failure to understand or failure for people in your firm to acknowledge certain things. Now, the fact is that there are all kinds of tools that will provide discounts, significant discounts for you on your professional liability. If you can prove you have a great, robust conflict system, which is primary, by the way. You have a legal administrator on staff. You have good case management software. And you have a bonded CPA. Let me go back here to case management software because I want to make a parenthetical point. I have found that it doesn't matter what kind of software you have, if you have the most sophisticated case management, or if you're just using Microsoft Office, most people only use about 20% of anything they have. So wherever you are, the real key is, I come across the most amazing things. I just started working in a firm up in Atlanta, 4 attorneys. And when I was up there and did an analysis, I said, do you have case management software? No, we don't have case management. All we have is tabs. A week later, I'm talking with them, and they were saying, oh, we got this thing called Practice Master or something. I said, you what? You can buy tabs separately, but it usually comes bundled with one of the good basic practice management software that's out there called Practice Master. And not only weren't they didn't even hardly know what it was. And here they had a powerful tool, but nobody had learned anything about it. Nobody had been trained on it. And here they had this great tool that they weren't even touching. Just astounding to me. Bonded IT as well is very important. So how do you screw up your coverage? Lie purposely or accidentally on your application. Because think about the malpractice insurance coverage itself. When you read it, first of all, they tell you everything that's not covered. There's 7 pages of things that we don't cover, and then not much on what we do cover. There's great information again. Professional liability insurance, everything you need to ask. Fact is, an emergency response plan is not a recovery plan. Emergency response plan is basically life support. Business recovery is how we get back to 100%. So you may have an emergency. What happens when we have a hurricane? What do we protect in a flood? What do we do? And so forth and so on. But that doesn't get me back to business. You need to be looking at the fact that for 72 hours you're going to be on your own. You might get a nice care package from the Red Cross or an insurance check, but 60% of businesses who experience a disaster never reopen. Why? Because after the first 72 hours, they have no clue how to take that next step. So a recovery plan is the next step. What happens? You can see by this time in developing this seminar, I was getting just a little off the wall. So what kinds of disasters might you have? I have a basic rule that I tell my clients. If you have more than about 25% of your revenue from any one client, you are dangerously at risk. Because what if they went away? Boom, hold at the waterline. Death or permanent disability of a partner. And by the way, think about that. If you're just in a 2-attorney firm or a 3-attorney firm, Do you have anything in writing that says what's my responsibility for my partner in my business if they can no longer participate? What do you do? Natural disasters. Let's not even go there. The fact is that that trust account could be one of the main reasons why they say, sorry, you're a good attorney, but you can't practice for a year. What would you do? What would be your agreement with your partners? Or would you just be taken off the letterhead and sent away? Theft. Would your firm survive these? The smaller you are, the more important every one of these issues is, because every one of them can destroy you. So how do you... Oh, I was getting flaky by this time, I can tell. Think about and prepare for not just the disaster, but the recovery. What can happen, and what are you going to need? You're going to need people. How do you set up an emergency response with your team, with your staff? What happens? Who calls who? What do we do? Who's responsible for what? Do we have inventories? How do we totally know for sure our data is protected? Our original software? That's one of the big problems. Yeah, we got great software. So everything crashes, everything's wiped out. Okay, well, let's start over. Let's reload the software. Well, where is it? I don't know. Space. Where would you be working if your space were not available? How would you replace the furniture, fixtures, equipment? And it's not, you might get a check. You might have the money to do it. But who's going to manage the process of rebuilding your practice? Who's going to be in charge? Is everything just going to stop for 3 months while you get reorganized? Clients aren't going to be happy with that. Do you have a reserve? Do you have something that you can draw on to close that gap? Here's the best reason to digitize. Oh, and that just makes the back of your neck kind of crawl. I spend a lot of time talking to people about this, but the fact is it's not just about, gee whiz, maybe I'll sell my practice one day, or how do I bring somebody else in? It's really risk management. It's risk management for your practice and your clients and your finances. And so it's important for you to be looking at that. So what would happen to your practice in the event of illness? So do you have someone standing beside you who is your shadow, your support, who can allow you to be the great attorney, but make sure that the details and everything is managed? If you are out, if you're sick, if you're on vacation, that there's someone there to continue the firm. And it doesn't have to be long-term, it can be short-term. You know, are you able to take a 2-3 week vacation? It provides for, virtually no small firm I know has a written succession or transition plan. It provides some very important protection. Bringing someone in that you may be going through the transition process with provides you with that second set of eyes and hands. It has the potential to increase your revenues even as you're starting to step back from your practice. It has the ability to build the asset value of the firm and allow you a place to come back and play even though you don't want to work very hard. You can still be involved, but at whatever level you choose to. Without a plan, and I will tell you this very directly, most small firm attorneys or sole practitioners don't go, well, you know, that's for big guys. I can't do that. Yeah, you can. You really can. And you should develop some kind of, if not a sales or succession plan, a transition plan. for no other reason to protect your clients. There's an article that I wrote a while back to get you thinking about that process, because the fact is that it does have value. It has a great deal of value to someone else to be able to build on your foundation. And if you don't exercise that, then you can, most attorneys just kind of like, okay, I'm retired. Give somebody my files, things of that sort, and walk away. And that's sort of the traditional thinking of attorneys is, well, I just work, and when I stop working, I'm done. But you really have built a business under there. And the most valuable thing is what gets thrown away at that point, and that's your goodwill value. It's not about files, it's not about facilities and equipment, it's about your reputation, your referral base, your former clients. That's value. And you can't exercise that well and get value out of it without a plan to step through that process. And unfortunately, as I say, there are a lot of older attorneys who don't have a plan who suddenly go down. They haven't gotten this in process, and so suddenly they're in the hospital for 6 months and the practice just explodes. It falls apart. So if nothing else, it's a type of risk management for you to make sure that you're bringing in someone that the plan is, I'm going to have them buy me out, or I'm going to transition it to them so that you can work in parallel for a period of time. And over time, you can turn over the client relationships, the referral relationships, and there is an agreement as to the value of that for the incoming person. All right. This is an important statistic. Florida Lawyers Assistants, another great, great organization, incredibly dedicated. But about half of the people that call them have issues around stress. And frankly, it's one of the major causes and results of grievances and malpractice. Stress, someone who gets so stressed out that they can't focus, that they get sick, that they whatever, causes malpractice and grievances. And then once you have one, you got a whole new layer of stress. So managing is the key to building growth with no cap. No personal boundaries. To decrease your stress, go to the root of the issue. Learn how to make it work better. So, what are the keys? I talk about that attorneys have built up emotional calluses. If I ask attorney, do you think you're working too many hours? And they say, no, not really. I probably work 60, 65 hours. And I go, say again, please. I really believe that what happens in the practice of law is we develop this incredibly high tolerance of pain. And that keeps us in this thing. Well, I'm exhausted half the time, but that's just kind of how the practice of law is. No, it doesn't have to be. You can build it differently. So understand that there is really hope. If you're frustrated with your practice, not enough revenue coming in, everything's falling apart, I can't find good staff, things of that sort, there are solutions to that. So stop tolerating it. Decide to make it different. The single most valuable thing that you learned in those, how many years of school? 20, 19? Was how to figure things out. So this is possible. If you decide, I need to have this different, I'm going to figure out how to make that happen. And then decide. Look, by October 1st, I'm going to be home every Friday night by 5:30 so we can go out to a movie. Tell your spouse, your significant other, make a commitment to them, because, man, they'll hold you to it. You know, wait a minute. So create some external pressure for you to implement the change, because you've got calluses. You're tolerating way too much because in some ways you think it's normal. Start asking, what do I need to figure out? What do I need to do to change? What do I need to read, discover, learn? Who do I need to talk to? What do I need to do? So learn what you need to know. Management, operations, technical issues, marketing skills. Get clear and conscious and make some commitments about how you're going to maintain your own health and how you're going to maintain your own relationships. Unfortunately, what law school created for most lawyers is sort of this belief that the law always comes first. And so that's why divorce, all the rest of it, because too many attorneys put their practice before their relationship, which really means before their personal life. What are you thinking about? What are you planning? What is your transition plan? If you're 40 or older, you should be thinking about transition, because it's also about growth. You know, I have one guy, every time I talk to him, he says, okay, I got 782 days before I'm supposed to be sitting on the beach at Key West. I got a plan. Now, you know, if he changes his mind, he's still got a great operation that he can just continue to grow because he's putting good people in place. So, again, there's a terrific personal and professional audit that is part of your materials from Lomas. Really, really good stuff. So risk management is really about your clients. It's about your income, certainly. It's about your career. Remember the dirt bike. It's going to happen. We just want to make sure that it's only a bruise, because it will happen. It's about changing how you approach your practice so that you actually like it and you can stay there and you can enjoy what you're doing. And it's about having a decent life. I'll do it later. Might not work. Start now. There's all kinds of help and guidance available from Lomas. Thank you.